Today topic is industrial disputes from the subject industrial relations. Industrial disputes are conflicts or disagreements between employers and employees over employment conditions such as salaries, working hours, benefits or security. The issue of disagreement is usually pay or other working conditions. During an industrial dispute, both the parties try to pressurize each other to agree to their terms and conditions. The industrial unrest manifests itself as strikes, lockouts, picketing, garrows, and indiscipline on the part of workers. Industrial disputes, in the sense, any clashes or any mismatching of opinions or any discomforts at workplaces arises between employees and management are called as industrial disputes. Types of industrial disputes. Industrial disputes can arise from various conflicts between employers and employees. Industrial disputes can be classified into four major types known as interest disputes, rights or grievance disputes, unfair labor practices disputes, and recognition disputes. And first one is interest disputes. Interest disputes are also called disputes of interest or economic disputes. In most cases, the disputes arises from the demands or proposals for improvement in wages, benefits, job security, or terms or conditions of employment. In present scenario, people are expecting somewhat of monetary benefits. If the company collects huge profits, they are expecting bonus, incentives, other monetary rewards. If the management giving such kind of facilities to the employees, simply they are enjoying with the working environment. If the expectations are not reached by the managerial people, employees are having such kind of issues. And second one is rights disputes. Grievance or rights disputes are also called as conflict of rights or legal disputes. These disputes take place from day-to-day working relations in the undertaking. Employee feels any discomfort, any slight changes in opinion matters or any perceptual differences are happen between employee and employee or employee and employer or worker and management or worker and worker, they are going to raise a complaint in the grievance redressal committee. The committee will scrutinize all the facts, then after they are going to suggest a solution. Third one, unfair labor practices disputes. Unfair labor practices includes pressure on employees when they exercise their rights to organize, take part in union activity, refusal to bargain, recruiting new employees during a strike, which is not illegal, creating an environment or actually creating an act of force or violence or stop communication, etc. If the management did any unfair practices which is forcibly implemented on employees or forcibly terminating any employee from the job, in such practices protested by the employees or their unions. Recognition disputes. Recognition disputes arises when the management of an organization refuses to recognize a trade union for the purpose of collective bargaining or to represent its members' employees in case of a conflict or dispute. If trade unions are formed in any organization, the trade unions may fight against management practices and they may support employees and their practices. For strengthening the employee unions, the management are not allowing the trade union formations and they won't recognize the practices of any trade formations. This also leads to somewhat of dispute in between employee and management. Procedure for the settlement of industrial disputes. Industrial disputes arises when employees and the employers fail to sort out their differences. Industrial dispute is always harmful to all persons associated with such industry, as it affects all stakeholders, management, employees, economy and society. The employer suffers losses in production, revenue, profits and even sickness of the plants, whereas the employees may suffer due to loss of wages and even jobs. The redressal of industrial disputes is very pertinent for effective functioning of the industry. If the industrial disputes are continuously occurs in the practice of day-to-day operations in any organization or any business, in any company, it affects all the activities of the business, employees and employer performances as well as growth of the industry. The Industrial Disputes Act 1947 provides for the investigation and settlement of industrial disputes through various mechanisms. The following are some of the methods for the settlement of industrial disputes. And first one is collective bargaining. Collective bargaining is the process of settlement with a huge discussion between the representatives of employer and the employees. These two parties, they are trying to solve and give a proper solution for the dispute which is arises between the parties. The settlement is a negotiation technique, and the technique collectively chosen by the both parties and their representatives. Grievance redressal. Grievance redressal is also one of the redressal mechanism which is provided by the management within the company, and the company is established grievance redressal committee for the settlement of industrial disputes. This committee will take care of any grievances are received from the employee side. Grievance redressal procedure starts with filing a complaint with a proper documental evidence from the employee. The documental evidence received by the management representatives or the supervisors or the higher level employee within the organization, they are conducting proper investigation. Then after they are going to conclude a reward system to the employee. Arbitration. Arbitration is a method of mediation. The outside parties, those who are having a complete knowledge on the settlement of industrial disputes, that person act as a arbitrator, and this person will resolve disputes between employee and employers or their representatives like trade unions or employer associations. If the arbitration process is not satisfied by the parties, then after they are going to apply in the conciliation board. And fourth one is conciliation. Conciliation also mediation technique, and the conciliation officer is appointed by the government. This conciliation officer will provide a suitable judgment or a reward to the dispute. If the judgment or reward is accepted by the people, the disputes are resolved. If the people are not satisfied with the conciliation procedure, then after they are going for applying a complaint on court or jurisdiction. If parties are approached conciliation, they don't have any choice to forward for the adjudication system. If they want to conclude at arbitration or conciliation, then only they have to approach. Otherwise, they no need to consult any conciliation officer or any conciliation body. And last one, adjudication. Adjudication is a method of a deep investigation by the court authorities or tribunals, district tribunals or labor courts, state tribunals or national tribunals are undercomes the adjudication. These courts will collect all the relevant information regarding the dispute, then after they are going to provide a settlement. Conclusion. Understanding the nature of these disputes and the methods used to resolve them is crucial for maintaining industrial harmony and ensuring fair treatment for both employers and employees. Thank you.